The general rule that unless otherwise agreed, the goods remain at the seller's risk until the property is transferred to the buyer. If there is any agreement, then automatically it changes according to the agreement made between the buyer and the seller. Constructive delivery takes place when the person in possession of the goods acknowledges that he holds the goods on behalf of and at the disposal of the buyer. Warm welcome to 4th Sem BCom student. The subject we are discussing business regulatory framework. In last session, we have discussed about implied warranties and conditions. I am Professor Rajesh L.R. from Department of Commerce and Management from Vidhyaashram First Grade College, Temple of Excellence. In the previous session, we learned about and we had a discussion on warranties, condition and passing of property of specific ascertained and unascertained goods. In today's session, we are going to discuss about passing of risk, transferring of ownership from one person to another person, and if anything happens, who is the responsible for that one? So now for that clearly we are going to see that one. When the title of the goods is already transferred, the person who is having the title of the goods, he should be held responsible for all the damages or the loss, whatever. The risk has to be borne by the title of the goods. Means nothing but, in simple words, the risk should be borne by the owner of the property and not by the person who is not in the position of ownership. Transfer of title by person, not the owner. Delivery, acceptance of goods by the buyer, installment delivery, and filing a case for breach of contract. Suit means filing a case. On what grounds we have to file a case, when we are going to file the case, we are going to discuss these concepts in the session. The first one, passing of risk. As I said to you people that one, the general rule that unless otherwise agreed, the goods remain at the seller's risk until the property is transferred to the buyer. Till the rights, the goods has been transferred from the seller to the buyer, it remains in the hands of the seller. So now, next we have here, but when the property is transferred to the buyer, the goods are at the buyer's risk, whether delivery has been made or not. It is just that when the title of the goods has been transferred from the seller to the buyer name, and if the buyer has still not received any goods or the property of the goods, he will be held responsible for all the damages or the loss, whatever takes place, not by the seller, because the title is already transferred from the seller to the buyer. Rule is known as respect gemino. The loss falls on the owner. Means the loss should be borne by the owner, like for example, even it may be a seller or buyer. It depends on in whose name the title of the goods are there. That's a major thing. But the parties may agree that risk will pass at the time different from the time when the ownership is passed. Example, the seller may agree to be responsible for the goods even after ownership is passed to the buyer or vice versa. They're saying that one, in certain cases, when the seller has agreed that one, till the goods reaches the buyer place, the entire risk will be borne by seller himself, even though the title of the goods is transferred. In some of the cases, the agreement will be made in such a way that the title of the goods will be transferred immediately, but the goods will be delivered later. So, till the goods reaches the buyer place, up to that position, up to that time, the entire risk should be borne by the seller himself. After reaching to the buyer place, the buyer will be the responsible, or he has to borne the entire risk for the damages. Exception to the above general rule, if there is an agreement between the parties, means if there is any agreement, then automatically it changes according to the agreement made between the buyer and the seller. If there is agreement for the delivery of goods are delayed either due to buyer's or seller's default, goods are at the risk of party in default. It depends on that one. Sometimes the seller has made the default to deliver the goods. Means instead of sending the goods on 1st May, he'll be sending on 4th May. So now the owner will be the responsible for the damages. The goods already has been sent to the buyer, but buyer was not there to receive the goods, and the goods has been delivered after 2 days, and the person who is the owner, he has to bear the risk. Relevant case law: Consolidated Coffee Limited versus Coffee Board, Multanmal, Champalal, Visha and Company. So this is the relevant case law what we have. Both the cases, you'll come to know what has happened. Next, we have a transfer of title by person, not the owner. The general rule is that only the owner of the goods can sell the goods. Means here, the person who's having the title of the goods, he can sell the goods and not by the other person. Exception to the general rule: sale by a mercantile agent, sale by a co-owner, sale by a person in possession under voidable contract. The first will go for mercantile agent. A buyer will get a good title, means the title of the goods, if he buys in good faith from a mercantile agent who is a possession either of the goods or documents of title of the goods with the consent of the owner. Means here the middleman is selling the goods to the buyer on behalf of the seller and is going to transfer all the goods and the title in the good faith. Sale by a co-owner: when joint owners are there, the one person is selling the goods to the another person. Sale by a person in possession under voidable contract: a buyer buys in good faith from the person in possession of goods under a contract which is voidable but has not been rescinded at the time of the sale. Means they are saying that when it was not made agreed in certain concept, that when the possession of the goods means the agent is having the goods with him, he wants to sell the goods to the person who wants to buy that one. But actually the owner may be any other person, but only the goods are there with me where I'm selling the goods to you, not the title. The title should be transferred by the owner who is the actual owner of the goods. Sale by seller in possession after sale: where a seller, after having sold the goods, is in possession of the goods and again sells them to a person who buys in good faith and without notice of the previous sale. Such a buyer gets a good title of the goods. Means sometimes a seller has sold, A has sold goods to B. The title was not transferred, it was agreed and everything was over. But suddenly A sells goods to C with the title. But C is not aware that the goods has been already sold to Mr. B, but it was not given the possession of the goods or the title of the goods was not transferred. Now it has transferred to me and now the C will be the actual owner of the goods, not the B. Next, sale by buyer in possession. If a person has brought or agreed to buy goods, any sale by him to a buyer who takes in good faith will give a good title to the buyer. In any of the above cases, if the transfer is by way of pledge or pawn only, it will be varied as a pledge. They are saying that sometimes when the goods has been pledged and we have taken the amount as a debt from a person, in such cases, the person who is having the goods as a pledge of property, he can sell that one in case if there is any default made by the person who has taken the loan. Estoppel: if the true owner stands by and allows an innocent buyer to pay over money to a third party who professes to have the right to sell an article, the true owner will be estopped from the denying the third party's right to sell. Means here, sometimes seller may be quiet in certain cases. He will give the rights to a third party to sell the goods and make the buyer to buy the goods above the market value and other part whatever we have here. Seller by unpaid seller: where an unpaid seller has exercised his right of lien or stoppage in transit and is in possession of goods, he may resell them and the second buyer will get an absolute right to the goods. Seller by an unpaid seller means here the seller has sold the goods to the buyer, but buyer has not paid the actual amount. Now the seller has all the rights to get back the goods from the transit and sell the same goods to the another party. Sale by a person under other law. Means when we pledge the goods here, when the repayment has been not made by the person who has borrowed the money, the person is having all the rights to sell the property against pledged thing, whatever they've made and agreed in such a way that when if the repayment of the debt has been not made, the goods can be sold without any information to the person who has borrowed the amount. Delivery, voluntary transfer of possession from one person to another. Actual or physical delivery takes place where the goods are handed over by the seller to the buyer or his agent authorized to take the possession of the goods. Here, sometimes the goods will be sold to the buyer and the actual possession of the goods will be transferred from the seller to the buyer, and all the rights will be transferred and the goods will be handed over to the either to the buyer or as per the instructions given by the buyer to send the goods through the agent, and the agent will take all the risk from the on behalf of the buyer. Constructive delivery takes place when the person in possession of the goods acknowledges that he holds the goods on behalf of and at the disposal of the buyer. Is informing us that when I am taking responsibility to sell this property on behalf of the seller, you can get this property at this particular rate or after completion of the entire process. Symbolic delivery is made by indicating or giving a symbol. Here the goods themselves are not delivered, but the means of obtaining possession of goods is delivered. Example, by delivering the key of the warehouse where the goods are stored, bill of lading, which will entitle the holder to receive the goods on the arrival of the ship. They're saying that when I'm handing over a small key, stating that this is in this key, whatever I'm handing over you, in that container, all the goods are there. When I'm given the key, handed over the key to the buyer, so it states that the goods has been delivered to the buyer and the buyer has to bear all the risk here. Delivery should have the effect of putting the buyer in possession. Means buyer should be responsible for the loss or the risk. The seller must deliver the goods according to the contract. Always the seller has to deliver the goods as per the agreed terms made between the buyer and the seller. The seller is to deliver the goods when the buyer applies for delivery. It is the duty of the buyer to claim the delivery. He has already sent the goods and it is the duty of the buyer to receive that goods. If he doesn't receive that goods, and he will be held responsible for the damages or the delay in claiming the goods from the places. And even sometimes if the goods has been returned back to the seller has all the right to sue the buyer. The place of delivery is usually stated in the contract. Always they'll say that in the terms of agreement between the seller and the buyer, the delivery place will be informed. And even in some of the cases, they'll clearly inform the timings, the availability of the buyer, and the mode of payment. Everything will be agreed on the terms of agreement made between the buyer and the seller. According to it has to be delivered. For example, if they say that my business hour is from 9 to 5 p.m., it has to be delivered in between 9 to 5 p.m. only. If it is delivered after 5 p.m., we will not consider that is the mistake made by the seller in delivering the goods. While the cost of obtaining delivery is said to be of the buyer, the cost of putting the goods into deliverable state must be borne by the seller. The transportation cost are the loading and unloading, what we are going to call. The loading charges have to be borne by the seller, unloading charges have to be borne by the buyer, or sometimes both the charges will be borne by the seller or both the charges borne by the buyer. It depends on the terms of agreement. Acceptance of goods by the buyer. When it is delivered, he has to accept the goods, intimates to the seller that he has accepted the goods. After receiving the goods, he acknowledges and he signs a document or a slip. It says that it has been accepted. Retains the goods after the lapse of a reasonable time without intimating to the seller that he has rejected them. Sometimes the buyer has rejected, but he has not intimated to the seller about the rejection reason, as well as he wants to send back the goods. In such cases, if the time lapses means it should be made within 3 to 4 working days. If he has not conveyed the message, it is quite understood that the acceptance of delivery. Does any act on the goods which is inconsistent with the ownership of the seller, example, pledges or resells. If the seller sends the buyer a larger or smaller quantity of goods than ordered, the buyer may reject the whole, accept the quantity, be ordered and reject the rest. Means sometimes I have ordered 1000 units. In certain cases, they may send 1500 units. In some cases, they may send 800 units. I have all the right. Either I can accept 1500 or I can say that one, only I'm going to take 1000 units and 500 units will be sent back. Or I've ordered 1000 units, but they've sent 800 units. You may accept 800 units or you may reject the entire 800 units. Installment deliveries. When there is a contract for the sale of goods to be delivered by stated installments which are to be separately paid for, and either the buyer or the seller commits a breach of contract. It depends between the buyer and the seller where they made an agreement in such a way that the goods will be delivered on installment basis. Whenever I'm going to deliver the goods to you, at that time, amount has to be paid according to the completion of the work or the goods whatever received by the buyer. Filing a case on breach of contract, where the property in the goods has passed to the buyer, the seller may sue him for the price. Means already the seller has transferred all the goods and the title in the name of the buyer, and he can file a case for not paying the amount whatever has to be paid by the buyer. Where the price is payable on certain day, the seller may sue for the price if it is not paid on that day. The buyer has agreed that I'll pay the amount to you after 30 days. If the buyer has not paid within 30 days or on the 30th day, 31st day, the seller has the right to sue the buyer. Where the buyer wrongfully neglects or refuses to accept the goods and pay for them, the seller may sue the buyer for damages for non-acceptance. Sometimes purposely he orders and finally he rejects the goods. For such things, the seller has all the rights to sue the buyer for claiming the damages what it has happened during the transit or the time of transferring the goods. Where the seller wrongfully neglects or refuses to deliver the goods to the buyer here, sometimes the seller may neglect to deliver the goods to the buyer due to certain reasons or to certain environmental conditions. He may not deliver the goods to the buyer. Now, the buyer has all the rights to sue the seller. The buyer has already paid the money to the seller, but the seller has not delivered the goods. In such cases, the buyer has all the right to file a case on the seller. In today's session, we discussed about transfer of risk, means who has to bear the risk, under what circumstances, and delivery of goods, and even the filing a case for breach of contract. In upcoming session, we are going to discuss the unpaid seller, auction sales, trading contracts involving rail or sea transit. This is the final concept what we are going to discuss in the upcoming session for the Unit 2. Thank you and namaste to all 4th Sem BCom students. In today's session, we discussed about delivery, passing of risk, and even the filing for the breach of contract. Thank you to one and all BCom students.